A 3-month-old baby dies on New Year's Day in the bathtub of a Motel 6. And now his mom is charged in connection to the infant's death because she was apparently on narcotics at the time he drowned. Today's story takes us to Kentucky, specifically a Motel 6, where our defendant, 36-year-old Amber Winstead, was staying from New Year's Eve to New Year's Day this year. It was the early morning hours of January 1st, 2025, New Year's Day, when emergency responders get a call about a young baby who's unresponsive. They rush to the Motel 6, get to Amber Winstead's room, and go into the bathroom only to find 3-month-old baby Kiari Winstead completely submerged in the bathwater. First responders did everything they could, check the boy's vitals, perform CPR, all of the things, but unfortunately it was too late and baby Kiari was pronounced dead. His mom, Amber, now faces charges in connection to Kiari's death. Here's what Amber says, that she has a history with narcotic use. She also admitted that in the day and hours leading up to baby Kiari's death that she was using narcotics. So sometime on New Year's Eve into the early morning hours of New Year's Day. During this time, Amber decides she wants to take a bath. She runs the water and brings in baby Kiari with her. She says she has the baby in her arms as she drifts off to sleep. And when she wakes up, she finds the boy unresponsive. Amber Winstead has another child too, a daughter. We're not going to list her name because it isn't in any court documents and it hasn't been listed by any local TV stations. But her daughter has posted on social media coming out speaking against her mom and basically saying it is her mom's fault that her younger brother is dead. And this daughter confirms the same story, that her mother was in fact on narcotics of some kind, that her mother decided to take her baby brother into the bathroom and into the bathtub, and that baby Kiari was in his mother's arms at the time she drifted off and then he died. So for all this, Amber Winstead actually faces charges, second-degree manslaughter. It came down on January 5th, and since then, she pleaded not guilty. Now, this is another really upsetting, heartbreaking case that we're talking about today, and we're actually going to bring in criminal defense attorney and former prosecutor Josh Corman to talk a bit more about the details. And Josh, I wanted to start right from the beginning. When we have a case like this, how does the investigation even begin?
So it sounds like in this case that probably a 911 call was made, paramedics and the police responded, because my understanding that the child was found in a bathtub in a motel. So I would assume that once the paramedics did whatever they could, law enforcement was also on the scene. And it sounds like there was a statement made or some information that was made from the defendant herself, as well as an unnamed witness. That sounds like they found the mother and the child in the bathtub, and then someone obviously called the police. So I think the investigators obviously would try to interview her, interview whoever this witness was, look through the motel room to see what they could find, if there's any evidence of narcotics used or something like that. Because there's a child involved, they may have had to get children's services involved in the case as well to see if there was any history or record, and then I would imagine that that's how the investigation took off from the motel room.
And you mentioned it right there that the defendant in our case actually admitted to narcotics use, that throughout the day leading up to her son's death, she was using all of this. Does that kind of seal her fate if she's confessing to these investigators, yeah, I did do this?
Well, it certainly doesn't help, right? And it makes me wonder with some of those issues, sometimes law enforcement arrives on a scene and they immediately just start asking people questions. There may be an issue in this for her attorney to figure out if she was in custody at that time, if she had been advised of her Miranda rights before she made a statement, if she could voluntarily waive those Miranda rights, if she was under the influence of narcotics or something. So there could be a lot of other issues, but certainly someone making admissions, that's why we tell clients you have the right to remain silent and you should exercise that right until you have time to talk to an attorney. However, that being said, I would imagine the paramedics and everyone is trying to figure out what was going on and what happened. And so it's quite possible she was not in custody at the time and made statements that could be used against her. Now, again, I don't know what kind of narcotics it is. Certainly that would play a part in it, or if they took her in, got a search warrant for her blood to find out what was in her system, I would think all those things would certainly come out later on in the case. And you're right that that's a tough case to have, and that's a tough charge right off the bat.
Yeah, the charge is manslaughter, which is pretty intense. It's second degree. Obviously, on Law&Crime, we talk a lot about murder. We have a couple of manslaughter cases here and there, but I wanted you to break it down a bit for me, the charge, just so I can and the audience can understand all of it. What is the difference between manslaughter and murder? And now she's charged in the second degree.
Right. So typically, and this is in Kentucky, so I can't speak exactly what the statutes are in Kentucky, but if you're talking about murder, then most of the time we think of murder as like premeditated murder. Someone deliberated or they planned it out, they thought about it and murdered someone. There might also be second degree murder where it wasn't deliberation or premeditation, but it was a knowing killing of another person. And then it kind of drops down from there to lesser included offenses or lesser offenses, and that's where you might get into, depending on the state, negligent homicide, reckless homicide, and manslaughter. It's my understanding in Kentucky, at least, the second degree manslaughter essentially is a wantingly causes the death of another person, which I think is pretty much akin to like a reckless homicide. Somebody basically did something without care, or they acted reckless and that reckless act caused another person's death. And so the statute in Kentucky, I know, lists some other examples of what they would consider to be manslaughter, and it lists like distributing drugs to somebody if that person then, I guess, overdosed and died because of those drugs. If you left a child under 8 in a car and they died as a result of that, I think Kentucky has already specified in the statute that those would be examples of what second degree manslaughter would be. But essentially, the difference between murder and manslaughter is what someone's mental state is, right? Whether they did something on purpose or they did it knowingly or they were reckless in how they were acting and it caused another person to die.
The way that you described it just there, to me, the charges sound justified. It doesn't seem to me, at least from what we know now, that she was hoping to murder her child. It wasn't her goal for her child to die, but she did choose to take these narcotics. So to me, that second degree manslaughter charge does make sense. But if we're putting on our defense attorney caps and thinking about it that way, wouldn't they argue this was a complete accident? She did not try at all. She shouldn't even be charged at all and hope to maybe have the charges thrown out?
Right. I think that's always going to be the goal for every defense attorney, right? Is to try to figure out, is there some way that you could get a charge dismissed, whether that means that there's some technicality where, there was an illegal search of the hotel room or her statement was taken illegally, or something like that. And then obviously, are the elements of the offense, are those elements that the government, that the prosecutor could prove beyond a reasonable doubt? And you're right. I mean, there are certain things that happen in life that are just tragic. There are horrible accidents, but that does not mean that there was criminal intent. That does not mean people should be criminally charged just because somebody died. And this very well could be one of those situations that this is a horrible and tragic accident for everybody, but there was no criminal intent in this.
Going back to what we talked about a bit before with the Miranda rights, this is something we talk about a lot here. We see it in movies and TV shows, the right to an attorney, right to remain silent, and how important the Miranda rights are. But in this case, we talked about how emergency responders would be there right on the scene and hoping to revive the boy. That would be their ultimate goal. So let's say, this is speculation, but let's just say that the defendant says everything right in front of these paramedics and says, I was using narcotics. Here's what happened. I fell asleep with the baby, and police overhear that. So they hear that she said it, but she wasn't Mirandized. So is that a huge issue if that was the case?
I think it certainly is an issue that I would want to know more about. So what Miranda is required if the person is in custody and being interrogated. So it's a two-part test. So, if in fact this was a situation where everybody responded, the paramedics are trying to find out what happened so that they can render aid, render treatment, then presumably she would not have been in custody at that point in time. And also, if the paramedics are the ones asking that and they're not being directed by law enforcement to ask those questions, then she wouldn't be interrogated under the law. And so Miranda, may not apply at all. But that's one of those things that anytime you find out that someone made a statement or they spoke to police, the first thing I always want to figure out is, what was the person in custody? Because oftentimes, as you can imagine, the police, they need to, their job is to try to ferret out crime and investigate something. And sometimes that becomes an issue whether they lawfully did that and whether they advised somebody, or if somebody was in custody at the time that the police officer decided to ask a question about the case.
So it seems pretty straightforward that the defense attorney is going to go through the steps, as you mentioned it, to figure out if she was Mirandized, if she should have been, all of that. So that'll be interesting to see how all of that plays out. And the other side of things is, regardless of whether she was Mirandized, whether this can be used, she did admit to using narcotics. And I do assume that investigators would want to test her blood, her urine to see what she was on, what she had used. What would all of that look like?
So I would think that the next step after the officers were at the scene and spoke with her, or did whatever they were going to do as far as the hotel room, they probably went and got a search warrant for the motel room, and they probably also got a search warrant to get a blood result drawn from her, and then that would usually get sent off to the crime lab to find out what was in her system. So it not only would show maybe what drug she tested positive for, but how much of those drugs were in her system. And then you'd have a toxicologist or somebody be giving information to the investigators and the prosecutors about what type of effects that would have on someone's body. And in this case, I guess whether that caused her to fall asleep in the bathtub or to lose consciousness because of the drugs, or whether this was just a horrible accident that maybe she had drugs in her system, but they were low levels, and this is just something where she was tired and fell asleep, and it's just a tragic accident.
You're right. There's a lot to look through in many terms of this investigation, and we still don't know for sure how much she had in her system, what exactly she did. So we're going to have to wait to see that part play out. My next question is about her as a mother. Looking into her past history, is this something investigators would do? Obviously, her son is 3 months old, so she's had him for 3 months. She has another daughter, too, according to social media GoFundMe page. Would investigators take a look back at her relationship with those children? I know the daughter is old enough to have social media post about this. Do you think investigators or even child services would want to talk to that daughter about her mom and what happened?
In my experience, absolutely. So normally, any type of case involving a child, whether it's child abuse or sexual abuse, there's two investigations that happen. Law enforcement does their investigation, and then the Department of Children's Services, or whatever it's called in Kentucky, Children's Services, would also be doing their investigation. And usually those two investigations will combine at some point in time. There'll be meetings with a prosecutor, and kind of all three parties would discuss whatever information they have and the facts of that for the prosecutor to make an ultimate decision of how the case should be prosecuted and what you should go forward on. So that may include historical information, if there had been any other allegations of child abuse or neglect or something, as well as, like you said, it could even include someone interviewing her daughter to find out if there has been drug exposure or prior abuse regarding the older child as well.
Let's say that this investigation does come out and some sort of bombshell is there. There were these past allegations of abuse. We have it on video. I mean, this is all speculation, but let's say that there is something prosecutors feel that's a red flag too. Do you think the defendant could face additional charges from her past as a mother if they warranted it?
Probably not additional charges from the past, but the issue would be is how much of that information they would be able to use in this current prosecution. So, normally, like, prior bad acts and uncharged conduct is something that would be inadmissible unless it is relevant to some exception under the evidence rule. Like for federal rules, that would be what's called 404B evidence. So as an example, you want a jury to hear the facts of this case and not render guilt or innocence based on someone's character or anything bad that they've ever done before. And so a lot of times that evidence would not be admissible unless there's some exception to that rule that would allow it, like absence of a mistake or fact. Let's say this exact same scenario had happened before, then there may be evidence to bring up that this was not an accident, this was pattern or something like that. But there's all kinds of exceptions to get into that evidence, and that would be one of those things that's heavily litigated between the attorneys, and ultimately the judge would have to make that decision of what prior allegations or prior evidence could come out again.
It's really interesting to hear how much work goes into a case because to me, sometimes it sounds open and shut. But based on what we've been talking about for almost 10, 15 minutes, there is a lot that is going into it. And actually, one of the reasons we wanted to talk to you today is because you have experiences on both sides of the courtroom, prosecution and defense attorney. So let's start with the prosecution side of things, the Commonwealth of Kentucky. Do you think they have a strong case against our defendant here?
Just from the little bit that we know, obviously there is a death, right? So certainly at that point in time, someone has to investigate and find out why did this child died and who should be held responsible for that. It certainly seems that the fact that the mother was there in the bathtub and there's allegations of narcotics use, that seems like, at first blush, that would be a strong case for the prosecutor to go forward on, which is, of course, why they have charged her already. She has a $100,000 bond, and will have to go through the process in court. So yeah, at a first blush, it certainly seems like there's a strong case for the Commonwealth on the case.
On the opposite side of things, she does have the right to have an attorney. So her defense, what sort of defense do you think her team could bring in a case like this?
Right. So I think, like I said, the first thing, I think in all cases like this, the defense attorney is going to want to look at the evidence and find out specifically, right? There's a witness supposedly, so you'd want to find out, what did that witness have to say? Like you said, any other history she may have. There's the Miranda issue, because she made a statement. Anytime you find out a client has made a statement to law enforcement, you should absolutely look in to make sure that that was taken lawfully, or if there's a way to have that suppressed and thrown out. And then again, the narcotics, what comes back in her blood. Oftentimes it takes the crime lab quite a while before those results will ever come back. So those are things that I'm sure the defense is going to be looking at, as well as the prosecution, to try to figure out how strong of a case it is, and what kind of defense that you can have, right? Whether it was just something where she was just exhausted and tired and fell asleep, or whether this was the result of losing consciousness because someone was so intoxicated on whatever kind of drugs it is that we're talking about.
I always have to wonder in these cases too, whether it would actually make it to jury trial or if it may end in a plea deal, because we know that's kind of the goal for everyone, not to have to go to jury trial. What are you hypothesizing based on what we know? I know there's still a lot of question marks in this case and we're early on, but what do you think will happen? Plea deal or maybe jury trial?
Well, just the odds are that a case would be worked out by plea. And I think that's pretty consistent across the country, that, probably well over 90% of the cases will be disposed of something other than a jury trial. Jury trials are lengthy, they're expensive, and they're also very risky, right? So in this case, I think the second-degree manslaughter carries 5 to 10 years in prison. And so it could be something that, depending again about her background and history and the facts that come out in the discovery and the investigation, there could be something where the prosecutor is willing to reduce the charge or give her some kind of a plea agreement that certainly she and her attorneys will discuss, and that may be in her best interest. Sometimes trials are great, but everything is about, I guess on the defense side, everything we do is about risk versus reward. Obviously, if you go to trial and you win, then that's fantastic. Your client goes home and the case is over with. But if you lose, sometimes we think of it like a trial penalty. The sentence that the judge gives may be far worse than whatever that plea negotiation settlement is. And so a lot of times, clients don't really have, I would say they don't have a choice, but it's a very difficult decision to say, I'm going to go to trial, knowing that I have this lesser charge and lesser sentence, and it may be too risky to go to trial and risk the possible punishment that the sentence carries by the judge.
Yeah, we'll see which way this goes. I know that's way down the line. What we are dealing with right now, though, is a $100,000 bond. Do you think that number is appropriate?
I don't know in Louisville what types of bonds are I guess normal. I would say in the jurisdiction that I'm in, $100,000 bond on a case like this seems about right. That's kind of what I would expect in my jurisdiction.
Overall, just a tragic case, still a lot of questions about it. So thank you, Josh, for coming on and breaking down what we know right now.
Absolutely. Thank you for having me.
Still a lot remains to be seen in the case of Amber Winstead. We do know right now she's being held on a $100,000 bond and is set to be back in court on January 17th. For Law&Crime, I'm Gillespie.